that you are not welcome. You are really most welcome to ask questions, to share concerns, stories, experiences, especially in terms of what we're talking about today. So please feel completely comfortable and relaxed and informal as we go through the slide set, and feel completely comfortable to stop me to ask questions. All right, let me share my screen and get going. Can I just have a thumbs up in terms of my screen being visible? I'm getting thumbs up. Thank you. Thank you very much, guys. All right, let's get started. We've got quite a lot to get through. So what are we going to be talking about until about midday? The FSCA has actually fairly recently come up with their 2025 3-year regulation plan. And we're going to have a quick look at some of the key achievements, some of the strategic priorities identified for the period from this year through until about middle of 2028. Across the sector updates, we're going to be touching on updating the COFI bill, joint standards, a couple of joint standards, information technology risk management, cybersecurity and cyber resilience. We're not going to be spending too much time on that because there is an ASISA Academy workshop which addresses that specific topic. Industry practices and treatment of unclaimed assets, what we otherwise refer to in the industry as unclaimed benefits. Quite an interesting joint standard on culture and governance in the industry. Securities financing transactions, in other words, scrip lending. A joint standard on requirements relating to beneficial owners. Requirements for institutions providing financial education initiatives. That's quite an interesting new development, which we're going to spend some time on. The requirements relating to third-party service provision and outsourcing. Levies and fees to be imposed on prudential activities, which once related to the Prudential Authority, which is now going to be reassumed by them, and then also looking at requirements relating to beneficial owners. Specific to the pension fund sector as part of the overall financial services sector, we're going to be looking at the draft conduct standard on Section 13B pension fund benefit administrators, communication of benefit projections to members, amendments to the conduct standard 1 of 2019 relating to Section 14 transfers, quite a big change, that's third from the bottom item, prudential standard on requirements relating to regulatory reporting and audited financial statements. Very substantial impact that is going to have on you and I. No less important, but probably less substantial are the changes proposed to the Regulation 28, Reg 28 quarterly reporting requirements, conduct standards relating to living annuities in an annuity strategy, and then in the pipeline, some comments on guidance notes and interpretation rulings generically. A quick dip into the reviews of Directive 8 and Pension Fund Circulars 86 and 90, financial education initiatives, trustee toolkit, a very interesting update in terms of some of the stats that has started coming forth as a result of that request for information from the FSCA. A quick dip into mainly the costs and the fee implications of the post-implementation of the two-pot reformation system. We're then going to be looking at Section 7B exemptions. There was an interesting court case determining whether time limits set by the FSCA are permissible or not. We're going to have a quick look at the Induplum ruling relating to LPI, late payment interest, prescribed by Section 13A of the Act. And then if we've got time still and you guys are still awake, we're going to have a quick look at some draft exemptions which are in the pipeline in respect of Section 14 transfers relating to so-called retail funds. All right, let's then get started without wasting another moment. Let's have a look then at this regulation plan. So the first thing we're going to notice is that for the first time, certainly in my experience in the industry, we now have two regulatory authorities who are either issuing guidance and regulations in their own right, excuse me, or to the extent that there's an overlap of regulatory interest, they will issue joint standards. So we've been used to engaging predominantly with the Financial Sector Conduct Authority, the FSCA, but as of fairly recently, the Prudential Authority has now, as we're going to see a bit later, become a much bigger part in our regulatory lives, because there's been a transition of prudential regulation away from the FSCA. They've been caretaking it effectively, away from the FSCA to the PA, to the Prudential Authority, which, as everyone knows, is housed within the Reserve Bank. So I really would urge everyone who is on this workshop and to carry that urgency on to others within especially on your board, to have a look at this document, which the FSCA put out very recently. It was released in the last few weeks. And it's from here which we've extracted almost all of the content, certainly in terms of headers, for today's workshop, the FSCA Regulatory Strategy for 25 to 28. What is it there to do? Well, the whole regulatory framework is there just as a reminder that the framework is robust, aligned with international standards, fit for purpose, and sufficiently flexible to position the FSCA and I would add the Prudential Authority now to meet their legislated objectives and functions. So the very first 3-year review came out for the period of 2022 to 2023, and what it's done is it's like all good and well considered regulatory plans, it has expanded, it has grown. So we've had, this is in fact now the third iteration of the regulatory plan, which is partly retrospective in terms of seeing what has been done, what has been achieved, but equally importantly, it is prospective in terms of looking forward in terms of what is still going to be done. So the one that we working on today is freshly minted, it's freshly printed. It was in fact issued earlier this month. So what does it include? It includes a performance update in terms of what has been done, kind of activities that have been achieved, summary of the projects that have been finalized from the previous regulatory plan, new project of strategic importance, obviously priorities in terms of strategy for the next 3 years, this year through until 2028, and a note in terms of the role and the streamlining required for interpretation rulings and guidance notices. So what is happening is that the regulatory framework has and continues to up its game very, very substantially. And we can be proud of, I know we have a number of challenges in South Africa, but we can be especially proud of the wider regulatory context and framework of the financial services sector, but especially within our own area and an ecosystem of interest, those regulatory frameworks and prescriptions relating to the retirement savings sector. So what kind of progress has been made from the FSCA's perspective? Quite a lot of work done on sustainable finance. There have been a green finance taxonomy, in other words, definitions and frameworks within which so-called green finance is going to be regulated, and that is expected as soon as next month. A disclosure framework, putting together a framework in terms of mandatory sustainability disclosure requirements relating to sustainable finance and the like, especially for large listed entities. So bear in mind, the FSCA is not just responsible for retirement funds, it's responsible for the entire financial services industry. So some of what we touch on today, I've tried to carve out that stuff which is simply not relevant at all to retirement funds. But there will be, for instance, and this is a case in point, where reference is made to a large listed entity, which is not necessarily of application to retirement funds, but we need to be aware of it. Here's an interesting one, which is gaining quite a lot of attention within the two authorities. Artificial intelligence and machine learning. Quite a close cousin to our cybersecurity and cyber resilience conduct standard, joint conduct standard, which I'll touch on a bit later. But what the regulators are doing is considering including a high-level governance principle set relating to the use of artificial intelligence by financial institutions into the joint standard. So when we see financial institutions as a term, as a definition, we are, as retirement funds, listed as falling within the definition of a financial institution. So historically, if you stopped somebody in the street and you said, what do you understand to mean is meant by a financial institution? They may say a bank, they may say a life insurer or a medical aid. We are, as retirement funds, specifically included in the definition of financial institutions. So, and I guess this is why we're spending Monday, the last Monday of July together. A review of the Financial Markets Act. Quite a lot of work has been done there. Support for Treasury in terms of finalising their review of the Financial Markets Act, just to make sure that all the proposed legislative frameworks and so on are internationally aligned. And what you will see and hear during the course of this morning's discourse is quite a lot of reference to not just fit for purpose, not just best practice, but alignment with international best practice. So we really are, in many ways, within the financial services sector generally, we are in many ways not just world class, we are also world leaders in terms of our technology and our regulatory framework. And this is another example of that. There's going to be a publicly available version of the Financial Markets Act published for public comment, and that's probably going to come out in the second half of 2025, or maybe the first half of 2026, as part of the normal public consultation process. Here's the transitional process we're in at the moment, by which I mean a transition of prudential regulation, which up until recently, has all been provided by the FSCA, which of course is there for conduct regulation. The transition of those arrangements from the FSCA to the PA, to the Prudential Authority, and that has been and continues to be a very significant piece of work that the two regulators are undertaking, in terms of resourcing themselves, in terms of making sure that the transition is seamless, that there are no sort of drop balls in the process. And they've, in fact, the two authorities have now established a working group to develop things like roadmaps and other related transitional processes in order to achieve those high-level objectives. Guidance notices and interpretation rulings. Anyone who goes onto certainly the FSCA website and looks at the guidance notes and interpretation rulings, there are stacks. Some of them are fairly elderly. Some of them have been around for a long time. Some of them are more recent. Because a guidance note or an interpretation ruling is seemingly elderly, doesn't mean to say it's not of application. So what has been identified, in fact, in last year's regulation plan, is the need to possibly look through a slightly different lens in terms of how they're going to approach guidance notices. I think it's going to be a more structured, streamlined approach to how those guidance notices are considered and made available to us. So one of the first very big aspects affecting our lives as board trustees and as principal officers, I'm delighted to see so many POs on the workshop this morning. One of the first big projects which the Prudential Authority is taking over is the long overdue update and upgrade to our pension fund audited annual financial statements, which falls within the regulatory reporting wider definition. So that prudential standard has reached quite an advanced stage. And the FSCA jointly with the PA are going to be submitting that to National Treasury for on-forwarding to Parliament in the very near future. And in fact, there's an intention to have that published within the next sort of six to 9 months. So as we're going to see a bit later, I do spend a bit of time looking at the annual financial statements, the proposed new standard there. Very big impact for all of us, but long overdue, because I think the current standard, and the format is really a bit dated. So the thing has been out for public comment for a while, almost for 3 years already. And what has also been developing is our old friend Reg 28 in terms of the quarterly reporting requirements for our funds, in terms of Reg 28 specifically, the so-called prudential investment limits. And anyone who's been involved in drafting or assessing or indeed signing off our fund annual financial statements, when we get to those schedules relating to Reg 28 compliance towards the end of our financial statements, it really is technically complex and somewhat challenging. So this new proposed quarterly reporting requirement for Reg 28 is again very welcome. We're going to spend a bit of time looking at that later this morning. The conditions for living annuities in an annuity strategy, that draft conduct standard is still under construction. I think it's overdue. My own personal opinion is it's overdue. We should have, for something as strategically important as drawdown rates and so on for living annuities, it's something that really needs to be accelerated. Couple of new projects that have been added to the 2025 regulation plan: amendments to the Financial Markets Act conduct standard. We're not going to be spending any time on this because it relates specifically to the so-called OTC, the over-the-counter derivatives industry. Some of the bigger funds may have a small exposure to the derivatives market. We are now permitted by Reg 28 so to do, but this new conduct standard will assist in regulating that process. A big change in our lives coming up is the new set of requirements, or the improved set of requirements relating to liquidation of funds. And anyone who's been involved in liquidating funds, not just the liquidators themselves, but of course the process of the selection and appointment by the fund of a liquidator, by the board of a liquidator, and then the process that follows. A number of matters continue to challenge the process of liquidations of funds, and of course the liquidators themselves. The current requirements and indeed the fees earned by liquidators are more than somewhat outdated and spread across a whole range of different notices. So this is a good example of a situation where a situation is developed where there are a number of different regulatory factors which need to be pulled together, not least of all the implications of liquidation insofar as the two-pot system is concerned, which now results in a misalignment between the existing regulatory documentation and the two-pot reformation structures. Projects that are going to be collapsed into the COFI bill conduct of financial institutions. We're going to be spending a bit of time looking at COFI in a moment. So a whole lot of stuff is going to be repealed. A whole lot of stuff is going to be amended and included in COFI. These are projects specifically relating to insurance. So the PP, the so-called PPRs, the draft amendments, the policyholder protection rules are going to be pulled into the COFI bill transition project. The regulations under the long and short-term insurance regulations are also going to be pulled into COFI, as will be communication of benefit projections to members of pension funds. That's third one of great importance to us. I'm not saying that the first two are not important. And those of us who are invested through a policy of insurance into a life office, who then goes and on-invests downstream our members' funds. Very important that we are aware that we as the fund, as the investing fund, as a policyholder, therefore, understand the new and revised policyholder protection rules, the so-called PPR rules. All right, having mentioned COFI, let's have a look at where we are and what has been achieved so far. Is everyone fine so far? I am going quite quickly because there's quite a lot of content to get through, but please do interrupt me and stop me. It also gives me a chance to have a swig of water on the side here. All right, I'm not seeing any hands. Let's carry on. All right, so let's just from a high level view recap the purpose of the conduct of financial institutions, the so-called COFI bill. It's there to incorporate and consolidate all of the principles and conduct which are sitting at the moment in quite a bewildering array and different forms of legislation, of regulation, of prescription. So it really is an attempt to pull all of these strands, these twines, which make up our current certainly a great part of our current regulatory context, to pull it all under one piece of legislation. That's why it's taking so long, because the scale and the complexity and the challenges of the project are really very, very substantial. So whenever we talk about COFI, it's important just to bear in mind, what the whole purpose of it is, to pull as much together into a single piece of legislation. What it's going to do, it's going to streamline the legal landscape for conduct regulation across the entire financial sector. So that definition I talked about earlier in terms of financial institutions, it is very, very, very wide. Retirement funds are simply one part of that definition of financial institutions. It covers, as we're going to see in a moment, the entire financial services sector, and therefore the time taken and the complexity involved in getting COFI to over the line. It's going to give legal effect to market conduct, which is a very important development, because market conduct so far has really been sitting in a number of conduct standards, guidance, notices, interpretation rulings. What COFI will do is it'll actually give legal teeth to the market conduct. It also aims to strengthen customer protection by establishing a single comprehensive market conduct law. That's a bit of a mouthful, but what it means from our TCF, from our treating members fairly, what I call the TMF in our world of retirement funds, treating members fairly. Members, we're going to have to comply with a single, very comprehensive and far-reaching market conduct law. Our members, on the other hand, are going to be able to rely on and seek protection from that piece of single comprehensive market conduct legislation. It's also going to give more flexibility and regulatory, practical regulation controlled by the two regulators, Prudential Authority as well as the Conduct Authority, and then give legal effect to a number of the transformation and inclusion priorities which have been established. So let's have a look at some of the in a bit more detail, some of the changes, some of the areas which are going to change. So the Financial Sector Regulation Act remains very much in place. And I'm going to call that the FSRA going forward for the purposes of our workshop. Excuse me. So sitting within the FSRA are a number of existing financial sector laws. So the COFI has to kind of bond with and marry up in terms of principle with the FSRA, which is a source of a number of very important existing definitions like financial customer, financial institution, product, service, governing body. Very important that our board's trustees are included within the definition of a so-called governing body. We're trying to move away from a tick box approach. That's a very important high level strategic objective. And any one of us and I'm sure it includes all of you on the workshop this morning, we are so reliant or possibly are excessively reliant on being presented with a schedule where there are a number of compliance and prescribed activities or to-dos which simply have a yes or a no box to be ticked. Often those boxes are ticked not even manually, they're ticked with a little tick icon from an electronic file. The dangers of those is our industry tends to simply replicate that tick box. So we don't so the reliability of the tick box has been proven to be not that great. So as the second bullet point indicates here, we're moving away from a tick box approach to regulation to principles based. Okay, an example of that is and apologies to those of you who've heard my analogy before. If we've got a speed restriction on the side of the road and the speed restriction is 80 kilometers an hour, let us say, a tick box approach would look like this. I'm driving along in my motor vehicle, irrespective of whether it's night or day, good conditions, bad conditions, fog, potholed road, animals crossing, proximity to a school. The tick box exercise says, I'm permitted to do 80, so I'm going to do 80. And provided I'm not exceeding 80, I've ticked the box. What the principles-based view is substantially different from that. What the principle-based departure point is, even though there is a maximum speed of 80 kilometers an hour, that doesn't mean to say that if it's dark or if you're driving through heavy rain or if you've seen animals at the side of the road, that you should continue to drive at 80 kilometers an hour, because it is legal from a tick box perspective, but the principle is that the circumstances of the situation need to be taken into account in terms of determining what an appropriate speed is to drive at any particular point in time. So what the driver has to do, and from our perspective, principal officers and boards of trustees, we have to look not so much at a binary outcome, yes or no, but do the circumstances and the factors present within a particular part of the regulation of our funds, are they appropriate for the circumstances?
Looking at that, there are different sections that they looking at.
I think we've got somebody, Gugu. I was just going to ask Gugu to mute a microphone there. All right. What COFI will do, it will end up in a number of financial sector laws, in fact, being repealed in due course. The one is the Long-Term Insurance Act, which is a very big implication, obviously, for the long-term insurance industry. The Short-Term Insurance Act, and a number of others, including, interesting, the FASE Act. Look at that, 1/3 from the bottom, Financial Advisory and Intermediary Services Act. That will be repealed and withdrawn eventually. But of course, all of the principles sitting within FASE will be included in COFI. Credit Rating Service Act and others which are not of that huge relevance to us. Sorry. What COFI will then also do is amend. These won't be repealed. These will be amendments to the following acts: the Financial Services, the Financial Sector Regulation Act, as we've talked about already, the Insurance Act, Pension Funds Act. Big changes coming up to the Pension Funds Act, which in fact may be renamed the Retirement Funds Act. But let's see what happens there. We're also used to talking about the PFA, aren't we? Other amendments to Financial Markets Act, Collective Investment Schemes Control Act, etc., etc., etc. So COFI is probably from a sectoral perspective the single biggest legislative and prescriptive change basically since 1956, which is when our current Pension Funds Act was promulgated. The history of the COFI bill: it was initiated before 2024. Focus then moved across onto the two-pot system. It's planned to be implemented in 2 stages. First of all, a harmonization project, because we don't want to throw the baby out with the bathwater. We want to make sure that that minimal harm and disruption is brought about by the implementation of COFI. And then once that harmonization phase has been completed, everything that remains outstanding will form part of the phase 2. So the whole process of transition, of repeal, of amendment, of inclusion is going to last for a fairly long period of time. The estimate is 3 to 6 years. There have been a number of delays already in terms of the process because of its complexity, but that is the target. So within that transition project, there are 3 different sub phases. The first one is obviously the initial high-level design of the new regulatory framework, as we've discussed it. The second sub-phase is targeted consultation with you and me, with the public, with all the stakeholders in the wider financial services sector. And then phase 3, which is where the detail is going to become so important, is the transition of the regulatory instruments away from the current sectoral laws which legislate and control the industry into and underneath COFI. It's a very, very substantial process. So this transitional project is happening in parallel with the lawmakers, with the law writers, and the timeline that we talked about earlier, the 3 to 6 years, will depend then on the finalization of the bill itself. And for those of us who lived through, and I think it's probably all of us on the workshop this morning, all of us who lived through two-pot, one of the single biggest challenges, if not the biggest challenge of two-pot, was the lack of preparedness and finality of legislation before we as funds were able to give effect to that legislation in terms of rule amendments, importantly, and then the rollout of two-pot. So I think the lesson that has been demonstrated by two-pot is spoken to in the second bullet point here. The legislation must be finalized before the rollout starts. We cannot have, and I'm sure that's the lesson learned by the legislature. We cannot have a situation where the industry is trying to adapt and comply with legislation which is still in the process of being promulgated. So, as the third bullet point on the slide says, the Conduct Authority will prioritize certain themed frameworks over others, so that we have a staggered approach, so that certainly the retirement fund sector is not swamped by the process of the implementation of COFI. So a very recent update: the state law advisors, in other words, the legal specialists who receive and view the final draft legislation or the pre-final draft legislation, they've issued what's called a certificate. So they seem to be happy by and large with the content of COFFEE. What National Treasury now do, because of course they are the custodian of all of the regulatory, both prudential as well as conduct. Treasury are going to prepare an explanatory memorandum for the Cabinet for discussion and understanding, so that when the COFFEE bill is wheeled in front of Parliament during the latter part, the second half that we're now in of 2025, Cabinet are in a position to make a well-considered and a well-informed, or initiate at least a well-informed interrogation and discussion. And at the same time, the FSCA is developing an implementation plan by carving up the roadmap forward into a number of dedicated working groups, so that that implementation, rollout and implementation goes as smoothly as possible in terms of that harmonization intention. So once those processes have been finalized, we will then be included by the FSCA in terms of an outline of that implementation plan, what has to be done, by whom, by when. And then, of course, there will be an ongoing process of stakeholder engagement and consultation. So in line with the FSRA, in terms of the transitional arrangements, as we said already, the prudential regulation and supervisory functions for a number of sectors, a number of stakeholders within the sector, including retirement funds, has already started moving to the Prudential Authority. And that's why we're starting to see, for instance, an increase in the number of joint conduct standards. So everyone who's been involved in the cyber security and cyber resilience conduct standard 2 of 2024, you will have seen for the first time, possibly, the Prudential Authority as well as the Conduct Authority starting to impact on our lives, and eventually all of the prudential regulation will move to the PA. You know, so we're so used to engaging solely and exclusively with the FSCA, but as I've described, certainly the prudential regulation is starting to move across to the Prudential Authority, and that is set to take effect within the next 9 months or so. So that's really just around the corner when you think about how quickly time is flying by. A number of joint workshops and samenwerking methodologies and mechanisms between the FSCA and the PA have already been established. A number of detailed roadmaps are currently in existence and are being fleshed out and will become available for communication to the wider industry and especially our own retirement savings sector in due course. So expect quite a lot of information, not just on COFFEE itself, but also this transition and the split away from the FSCA of prudential activities and regulations insofar as it affects retirement funds. There are going to be a couple of frameworks which have been prioritized by the FSCA. The first one is a so-called fit and proper framework. And the second one is titled a risk management and internal controls framework. These are overarching descriptions of what those particular frameworks will contain. So when we do see them, when we have speak of these in the industry, we should kind of be aware of what's heading our way. There may be a delay to the implementation of these two framework methodologies we've just talked about. going back to that lesson that we've learned from Two-Pot, the COFI bill must first be promulgated. It must be discussed in cabinet. It must be, to the extent that further work needs to be done on it. We've got to get the legislation finalized, signed off by the cabinet, gazetted and signed by the president, and it's only then effectively that those frameworks that we talked about can then start being fleshed out and given effect to. What I've done is at the end of each section, I've also put a brief slide together in terms of the implications of what we've talked about in that particular section relative to us as retirement fund trustees and principal officers, I would add. If you hadn't realized it already, there are enormous and numerous implications for us as trustees. It's going to change the legislative framework dramatically. We will still recognize certainly the principles that we all know and have grown to respect and get used to, but the changes and the location of the legislation of regulation is going to be substantially different. And of course, with that change comes complexity. The complexity is understanding the changes, where the transitions are happening. Where do we now go for information? Where do we go for advice? How do we go with this breaker of change which is breaking over us? And then more importantly, once all of this is crystallized and settled, what are the compliance implications? How do we make sure that we have changed our systems, our mindsets, our methodologies within the retirement sector to make sure that we are in fact compliant with the new COFI? And I think the single biggest step forward is going to be, once it is promulgated, is taking apart the legislation. Of course, the pension fund legal fraternity are going to be very involved in that. Any thoughts or views or observations in terms of COFI before we move on? I'm not seeing any hands. So either I've lost everyone or everyone is reasonably comfortable with what we've talked about. All right, let's move on. Sharif, Afifa, is that a hand up just to say you're happy, or do you want to come in with an observation?
No, happy, David.
You're happy, and I'm getting Pierre is saying is happy. Sharif, welcome. Nice to see you on.
Thank you.
All right, that's COFI. Let's move on to one of the new joint standards. So whenever we see joint, the word joint, we are expecting to see the involvement and the holding of the stake by both jointly the Prudential Authority and the Financial Sector Conduct Authority. That's what we mean by joint. And increasingly, we're going to be seeing these joint conduct standards coming out. So the background for the IT risk management joint standard, we all know from our cybersecurity and cyber resilience work that we've had to do recently, that IT represents a significant risk in terms of technology failures, et cetera, viability. We need IT governance and risk management, which are fundamental for a financial institution, which, to repeat, includes us as retirement funds, to achieve our various objectives, and in terms of our particular world, optimizing our members' retirement prospects ultimately and their beneficiaries. So what the conduct standard requires is financial institutions to fully understand our IT risks and to put appropriate risk management systems into place. And a subset of those risk management systems are those which we are now obliged to comply with in terms of cybersecurity and cyber resilience. So there have been a couple of joint standards, draft joint standards out on IT risk management. And the current status of that is that the joint standard took effect about 6-7 months ago, towards the middle of November. That's what the information communication came out, spoke about. That's what it looked like for those of you who haven't seen it. Again, observe the two regulatory agencies at the top of the joint conduct standards. We've seen the FSCA and the Prudential Authority, which is housed within the South African Reserve Bank. What are the implications of the IT risk management joint standard? Very significant implications for self-administered funds, where compliance sits within the fund itself. Equally, but on a contractual arm's length basis, is where we have third-party administrators, which seems to be increasingly the case. So to what extent are our third-party administrators compliant on our behalf on an agency basis for compliance with that new joint conduct standard? If we're investing into or if we are board of trustees of an insured or a sponsored fund, very real implications for that as well. And other involved service providers who have an IT plugin to the operations and the administration of our fund, like investment managers, tracing agents, legal advisors, auditors, I would add to that as well. So for those of you not aware of or haven't had a look at that new joint conduct standard in terms of IT risk management, do have a dip into that. I touched on cybersecurity and cyber resilience. I'm not going to spend too much time on this, but just give you an update in terms of where we've got to. So at a high level, we know that both regulators have the responsibility to maintain financial stability, so-called, in the country, and that's why they've come up with the joint conduct standard on cybersecurity and cyber resilience. Here is a list just for everyone, for everyone's recap and reminding. Here's the use of that term, financial institutions, which, as we know, includes retirement funds, and that cybersecurity requires, or compliance with the conduct standard requires, a cybersecurity strategy and identification of so-called information assets in our business, the business of our funds, cybersecurity practices. I'm not going to spend too much time on these specifically. Limited access to authorized users only, data loss prevention policies, cybersecurity awareness programs, etc., etc., etc. That all sits in the joint conduct standard, and of course the ability to test cyber resilience. We all had to comply as an industry by the 1st of last month, 1st of June 2025. The ASISA Academy has been presenting quite a few of our half-day, 3-hour workshops on cybersecurity and cyber resilience, increasing attendance as awareness of the compliance requirements are become known. And it's also quite a technically complex and advanced area. And I include myself when I say very few of us have a comprehensive understanding of the IT aspects of cyber criminality. So if you do have a particular concern, or you feel that you may not be compliant as required, do feel free to join one of our ASISA Academy workshop on cybersecurity and cyber resilience. It's a fun morning, but because the content is so different from what we are used to in the industry, and therefore there's a lot of learning to be done. Let's not spend too much time in terms of what the objectives were. Let's have a look at that last bullet point there. I would draw your attention to. So this cybersecurity and cyber resilience is a very obvious compliance requirement, whereas the Pension Fund Act requires us if we don't have the expertise on the board. And I cannot believe, my own personal view, I cannot believe there is a single board of trustees in South Africa where they have on that board sufficient cyber and cybersecurity skills available to comply with the joint conduct standard. So we may have been to the workshops, we may have a broad understanding of it, but if we're going to comply with the JCS, the joint conduct standard, we will really need to consider whether we need to appoint and seek advice and guidance from either a cyber security legal or forensic specialists in that regard. Can I just while I have a quick sip of water here, any views in terms of implementation or challenges so far on cyber security and cyber resilience on the joint conduct standard? Who's actually managed to get their hearts and minds around that? Marilyn, welcome.
Hi there. Yeah, I think all I want to say is I still think, I mean, we overkilled, I think, I've been told. So, but at the end of the day, it's there. And we've done what we believe is required. But one of the things that really is confusing in the industry by many of the players, especially when we put out information to the various providers, some of them you mentioned just now as tracing agents, legal advisors, auditors, and so on. We used the same questionnaire because it was really difficult to decide what we should not do. But what we did say was, if something doesn't apply to you, just say. Yeah. Then we will look at it and we'll say, oh, but hell, this should apply to you, or no, we agree with you. This is more an administrative, or an administrator would have this kind of process in place, not really an auditor. So we found that people are struggling with what is those couple of words they used, size, complexity, and so on of your business. What is necessary and what isn't. Yeah. So if you say, well, okay, this is a fund and it doesn't have a system because the system belongs to the administrator. Now, effectively, the fund is going to tell the FSCA that they don't have a system and therefore they can't evaluate their system because it's actually the administrator's system. Does that require an exemption?
Yeah.
So we confused, as it says, you decide how deep you want to have this.
Sure.
But then you must also agree whether you must make your own decision whether this needs to be an extension needs to be given. And I think this is a little bit, we're sitting on an edge. And I've spoken to legal people and they're sort of not giving me anything that says.
Maybe they don't actually know the answer.
Yes. So I'm still sort of sitting here saying, should we be applying for exemption? I see somebody else's hand is up and maybe they've got an answer. So out of everything, I think there's overkill on our fund, but I think it's better.
Yeah. Overkill in those circumstances is overwork. Over compliance is better than under compliance.
Yeah. And then, of course, do we need to actually apply because we don't have some of the things as a fund as such?
Yeah. And it's that tricky situation, isn't it, Marilyn, where the old days of getting a certificate from a service provider that they are compliant. We are under no illusions that does not apply to cybersecurity and cyber resilience. We have to be able to demonstrate to both regulators that we as a fund are compliant, even though it's contractually on an agency basis undertaken by a third-party service provider, for instance.
Well, that's
fund administrator. Problem. Yeah, it's very tricky. Did I see another hand come up? It seems to have gone down again. But thanks for that input, Marilyn. All right, let's then carry on. The next little slot we're going to be talking about is is the conduct standard proposed in terms of the treatment of unclaimed assets. It's an interesting choice of terminology that the regulator has used here. It's what you and I typically call unclaimed benefits. But let's see what the developments look like. So they came up as the Conduct Authority about 3 years ago with a discussion paper on this, and it's gone out to the press, and there's been quite a lot of toing and froing, and there has been good progress made. This is what the discussion paper looked like for those of you who have the interest and the time to go onto the FSCA website and download it. It makes for some quite interesting reading, because of course unclaimed benefits, the estimates range from 45 billion up to sort of 70 or 80 billion rand across the whole industry. It's a major challenge, especially in the third world economic context of South Africa, and especially in light of the fact that the unclaimed beneficiaries out there are not always, but are in most part the most vulnerable beneficiaries in our ecosystem of the retirement savings industry. So it's highly emotive. It's difficult to achieve in terms of tracing, and so on, getting the money to those, especially the kids, the minors, or the elderly who are desperately looking for financial support and are sitting caught up in the process. So the concerns that are still being expressed is that customers, i.e. members and beneficiaries, are not being treated fairly. And this is the drive. This is the what's pushing the discussion around the paper, and especially to avoid a build-up of further unclaimed benefits into the future, because it has been a bit of a sort of a bulldozer effect. So what the purpose of the discussion paper was to do was just to check in terms of what the current status is of so-called dormant. Now, a dormant unclaimed asset, we're not used to that term necessarily, but that would apply to a bank. So a current account, a savings account that hasn't been moved, it hasn't, there's been no activity on it in 5, 10, 15 years, they would call that a dormant asset. Our world within the retirement savings industry is what sort of benefits remain unclaimed as the Pension Fund Act stipulates more than 24 months after it became due and payable. And really within the discussion paper, establishing current practices, what's happening out there, and how to manage this kind of swelling socio-economic factor of unclaimed benefits. And then to consider the supervisory approaches, what needs to be done, what's happening in the rest of the world. There's a good example of aligning with best international practice, and then to make specific recommendations to address the shortcoming. So there have been about a dozen recommendations that have come out in support of a sort of an industry-wide, holistic and consistent approach. And a couple of these are not new, but we're starting to knock on doors which we need to be quite mindful of and sensitive to in terms of unclaimed benefits. And the principle is now starting to settle of a potential legal compulsion. It's not final. It's simply being considered at the moment, where if we're sitting with unclaimed benefits within our fund, that we may have to, if this is the route that the regulatory process follows, we may have to transfer those unclaimed benefits into a central unclaimed asset fund, controlled essentially by National Treasury. That would be a very big change in our world. Is that somebody who wants to come in?
Yes.
I can hear a microphone on. No. So that would be a very significant change in terms of how we've historically dealt with unclaimed benefits funds within our fund, a possibility of having to move it under National Treasury. Here are the kind of the recommendations. which have come out of the paper. Just a couple which I'm going to highlight. There's the concept of a central unclaimed assets fund. The provision of restitution in perpetuity. There's an interesting concept. So we've got an unclaimed benefit. How long, whether we hold it within the fund or in some sort of central repository, how long have those beneficiaries got to claim it? What's on the table for discussion is should there be ongoing efforts in perpetuity to get that money to its ultimate beneficiary. Establishing a centralized database, so my fund's unclaimed assets, your fund's unclaimed benefits, putting everything into a central and centrally accessible database. I know the FSCA has started it already in terms of predominantly death claims. So it would be that, but on a much bigger scale, I guess. Also discussing a minimum threshold for unclaimed benefits. Do we go down to 50 Rand? Do we go down to, at what point in time do we actually say the value of the unclaimed benefit is simply not large enough to justify expending the money of the other unclaimed beneficiaries, if these unclaimed benefits are all going to sit in one place, in order to trace and bring those benefits to their ultimate beneficiaries. It brings to mind the whole aspect and industry of tracing. To what extent are tracing agents going to be obliged to fulfill certain criteria in terms of fees and costs and service levels, etc., etc. Unclaimed benefits is really quite a it really has some quite substantial socio-economic implications. And then using unclaimed the assets relating to unclaimed benefits for ESG and developmental type investments. So it's quite an interesting part of the process, part of the law. We did have some initial comments on the initial from the first discussion paper. But there has been an acknowledgement at the second bullet point here that the transfer to a central fund that would be controlled by National Treasury, it's not as straightforward as it looks. And that there are various complexities. Some of them are financial, some of them are administrative, some of them are social. For instance, what language would be used in order to access for beneficiaries, to access or at least make an interrogation, an inquiry as to whether an unclaimed benefit is there. There are a whole lot of there would be popular implications as well in terms of a concentration of personal information sitting within that central fund as well. So a number of complexities. So we are nowhere close to finalization in that regard. And the FSCA has acknowledged that they need to think, much longer and further in terms of whether there's going to be a centralized unclaimed benefits functionary. And what that's going to look like, how it's going to work, how it's practically going to be built and managed and governed by National Treasury. Sitting within that within that motion is how do we identify, monitor, manage, and trace unclaimed benefits. It's to varying extents, we're already doing that in the retirement savings sector, and it's a schlep, it's a burden. Somebody has to pay the costs of tracing and managing, and et cetera. So at what point in time do you say it's now starting to treat other members unfairly if excessive costs are incurred in terms of unclaimed benefits? Gugu, come in, please. Welcome.
Morning.
Morning.
Apology, I was cut off a bit, so some of what I might ask might already be covered.
No problem.
And I'm not sure whether the rules for a hand was it at the end of presentation or in the you can ask anytime.
No, you can ask anytime. Please
My
ask
question is
away.
on the previous slide, where you
Previous
said
slide.
is the unclaimed benefit must be transferred to the central, to the national. I think not this one.
Central unclaimed assets fund. This one here.
Yeah, but that if it's transferred there, what happened if we need to get the money back from there? Will they get it back, or how will they use the money if it goes there? I'm just understand because I think it's under government this fund, after that.
Yeah, it would be national. It would be national treasury. So Gugu, this is not finalized yet, Gugu. This is an idea. It's a concept which has been discussed. But your question is a good one. How do beneficiaries know, or unclaimed beneficiaries know, that they may have a claim to a benefit sitting in that? So they would have to set it up in a way which is user friendly, which is in different languages. It can't just work, for instance, on SAID numbers, because you may have a situation where you have a Malawian family, or you may have beneficiaries sitting in another SADC country who don't have South African ID numbers, who speak Portuguese, for instance. How are they going to be able to access the system? So it's quite a complex solution to quite a complex problem.
And how do they account for the accrued interest for that particular person?
Yeah, so the unclaimed benefit would simply grow with interest. So your question is also interesting in that how would the governors, the management of that central unclaimed assets fund, how would they invest that 40, 50, 60 billion rand?
Yes.
And they would probably invest it on a prudential basis, similar to what we have within retirement funds. Quite a lot of it probably in liquid form, interest-bearing assets rather than risk assets. But certainly it would sit there in perpetuity. It would sit there forever.
Noted. Thank you very much for your answer.
Sure, Gugu. Thanks for the question. All right. What are the implications for us as retirement fund trustees and boards and POs? Well, we also need to consider the default regulation 38 as it exists in the moment, which is the auto preservation and portability regulation. We are at the moment, unless we hear from a member when they leave the fund, we are obliged in terms of regulation 38 to auto preserve that member's claim. Now, before regulation 38, we would count down the 24 months after that benefit became payable, and it would then move to an unclaimed benefit fund, or the Act allows us to move it, especially a death claim, to an unclaimed benefit fund. What Reg 38 now does is it says if we haven't heard from the member, we may be in a situation where that claim simply sits within an in-fund preservation mechanism in perpetuity. To what extent are we obliged to activate tracing activities, for instance? So that's the first practical implication for retirement fund trustees. The second one is our new friend, the retirement component. Because we all now know that the retirement component within the two-pot system may not be paid out whilst a member is still alive until that member reaches normal retirement age. Now, if that member has become unclaimed, they may not access that retirement component even subsequent to the event. What do we do with it as an unclaimed benefit? And then another practical implication, as I've touched on already, what are the fund's obligations in terms of tracing those unclaimed beneficiaries? And at what point in time do we say the amount has been reduced by monthly administration fees, for instance, or other governance expenses? At what point in time do we actually say this is where we draw the line, and everything below this, we are not going to spend any more time or money on. All right, let's have a quick look at the joint standard on culture and governance. This is quite an interesting new line that the regulatory framework is moving towards. Quite qualitative, culture and governance. What's driving it? Well, the fact that we've got rapidly changing financial markets, changes in consumer, in other words, member expectations, and other sort of broader societal challenges. So what financial institutions have to comply with are the principles of being able to show that we are leading appropriately, that we've got a cultural commitment to embedding the principles of appropriate prudential management, fair treatment of members across all of the aspects of our funds. And again, being able to demonstrate that the fund is achieving the outcomes that we set out from a cultural perspective, rather than looking to the joint standard in terms of that old tick box, how we've done it. Can we demonstrate the achievement of these cultural and governance aspects? So work has been progressing on a joint standard from the two regulators on culture and governance requirements for the whole industry, including retirement funds. And we're expecting something out from PA and the FSCA in terms of targeted consultation during the current period. Those proposals will form part ultimately of the COFI transition project, but the timeline is obviously still outstanding in terms of what has to be done and by when. A joint standard on requirements relating to beneficial owners. This has its origins, of course, in the anti-money laundering and terrorism financing legislation, which is out there, including obviously our current grey listing situation, where we are subject to a number of requirements from the Financial Action Task Force, so that we can get off the grey list and back onto the white list. We're not going to spend too much time on this, but what the FSCA and the Prudential Authority are required to do is to set standards relating to beneficial ownership in terms of being able to trace who the actual owner is of a particular, in our case, investment in a retirement fund, a member's benefit, to make sure that it is not, excuse me, it is not affected by or involved in the proceeds of criminal activity. So there is the various processes are underway in terms of including this into a standard, which we're going to have to understand and comply with. And certainly the draft joint standard from the fund's perspective will be available in the very near future, before the end of this year. So what are the implications for us as fund trustees? Well, once that comes in, I'm afraid it's even more substantial, a probability of substantial systems changes, reporting implications. Once we do comply with that, we may need further IT data analysis, so that we can drill down through the beneficial ownership architecture and process, that we can get down to who the underlying actual beneficial owner is. And then, of course, what are the implications of non-compliance? What does the enforcement look like? Are there going to be fines? Are there going to be penalties? It's quite a tricky and potentially quite a scary part of compliance, where we're trying to protect the fund and its members. We're getting used to that now, in principle, at least in terms of cyber security and cyber resilience. Now, what we are going to be asked to do, in principle at least, is to be able to demonstrate that we're protecting the fund and its members from criminality in terms of proceeds of criminal activities, and how we can identify and how we're going to be obliged to identify who the beneficial owner is of a particular pension fund, share a fund, a fund credit. It's got some quite interesting implications. All right, let's move on then to the conduct standard on financial consumer education initiatives. Quite interesting developments here. I'm not seeing any hands, so I'm assuming that everyone is still with us and comfortable. Let's have a look at what is meant by these financial consumer education initiatives. So it was a draft conduct standard that came out about 2 years ago. And we have more clarity now. So the draft conduct standard was there to set the requirements for financial institutions when it came to providing consumer education. Okay, and again, like so many of these conduct standards, it's there to protect our financial customers, our members of our funds, by providing the financial customers with financial education programs. Now, initially, the wider understanding of our industry, the retirement savings industry, was this: that the financial education related to our members in terms of member communication, that has now been clarified. So what this conduct standard, in fact, has now been published and comes into effect, in March of next year. What we are now understanding for the first time is, despite the intentions, the good intentions behind improving financial literacy across the wider economy, that's what the conduct standard draft looked like. This is what the financial education content and intention behind the conduct standard in simple terms is set out as. So for our customers, and in our context as our members, to improve their understanding of financial products, become more aware of financial risks, make informed financial decisions, manage their financial affairs, it's all fundamentally important content. And that initiative would form part of and be driven by 2 key concepts: the program, which is the actual content, and any sort of initiative to introduce new content. Those were the target groups: the youth, women, small, medium, micro enterprises, older persons, previously disadvantaged. That was the target group set. Now that we've got some clarity after feedback, though, let me draw your attention to some very important aspects which have come out of this. Financial customers do not include boards of trustees. Okay, so this conduct standard does not cover education of boards of trustees of a retirement fund, of a pension fund. Okay, but also of even more importance is that the FSCA has now come out and they've confirmed that the communication to members is not regarded as a financial education initiative. So I think a lot of us were suffering from the misconception that financial education, so if we sent out a member communication to our members of the fund, this is what an annuity looks like. This is how your benefits are going to be distributed in the event that you die in service under Section 37C. What we now have is clarity that this conduct standard does not cover member communication. It's situations where institutions are set up specifically to provide financial education to its customer base as part of a financial education initiative. But importantly, what we are doing within our funds in terms of notes on member benefit statements, etc., or communication with our member, it does not include that. So So for the first time in a long time, we've got a conduct standard which doesn't really, unless we are actively involved in financial education initiatives as defined, it does not necessarily have the impact on us as boards of trustees as we initially thought. So having said all that, though, implications for us as retirement fund trustees, our members may be approached by other institutions providing financial literacy initiatives. Okay, so we need to be aware of the fact that our member base may need improved financial literacy. If we communicate with them as a board, that would not form part of this. It would have to be provided by an external financial institution, providing that and regulated by this particular conduct authority, this particular conduct standard. All right, there we've got a question. Busisiwe, come in, please.
Yes, morning, David. Morning, colleagues. Hope everyone is well. David, I have a question because what we do during our roadshows, right? When we have our roadshows, we'd have the member communication, these are your benefits, and then there'd be a topic that we choose for the particular roadshow. One of the hot topics, but it's never ending hot topic, is completion of beneficiary forms. So this just will have a topic like that. Yes, David, much to my dismay, hey? And proper completion of the beneficiary forms. I think that's a topic for another day. But what we also do during the time that we'll have the roadshow is what I organize for a financial advisor, somebody who's a qualified or certified financial advisor, to be present during the time of the roadshow, and that members have the ability to make an appointment with that person on a more formal basis, or if he's not busy, he or she is not busy, then they can just walk in and have a chat with them. Do you think that would meet those requirements? Because I'm just trying to think, how else can you ensure that and prove that you are giving the members financial literacy, or you've made it available to them? Because in as much as you can make the financial literacy available, members might not even be interested or might not even want to participate.
Exactly, yeah. So interesting question, Busisiwe, and so a number of lights went on in my mind as you were asking your question. The first one is that the Pension Fund Act obliges us to communicate with members. So that's we have an existing long-standing mandatory requirement to communicate with our members, and that is part of what you're doing. So that's great, and your compliance is good in that regard. To the extent that you now introduce a financial advisor into the process, we're starting to get into benefit counselling, for instance, which is also required by the regulatory framework, in anticipation, especially of members who are going to leave the fund, either because they've resigned or been dismissed, or of course, more hopefully that they're about to retire. So that financial advisor in turn is currently governed and prescribed. Their activities are prescribed by the phase legislation, financial advisory and intermediary legislation. So again, you are spot on with that. But to the extent that your activities fall under a wider form of member communication, those would fall outside of this new proposed conduct standard. So what you're doing at the moment is great. It's compliant as far as you've described in terms of all the other things. You don't, but whether it's your fund or my fund or anyone else's fund, to the extent that it's simply member communication in the hope of improving financial literacy, then you would not be, as I understand it, obliged to comply with this particular conduct standard. Does that make sense?
Yes, so I was thinking it's quite onerous, David, because I mean, you can set up training, send people material. I mean, member engagement was at a all-time high.
Yeah.
We were full to max capacity at the dawn of Two-Pot, because everybody
especially
actually
I was about to say, especially with Two-Pot. When do I get my money and how much?
Exactly. Those were the golden questions, and that's why people came to our roadshow. So for me, it's like I've seen it that member engagement is not very high, and participation is even lower. They might pitch, but participation and engaging it's not quite high.
Well, Cecilia, you're not alone. I promise you, you're not alone in your challenge in that regard. It's financial literacy. Just to pick up on one of my favorite subjects. It shouldn't even only be applicable to adults. Our kids should be taught financial literacy. What is a bank? How does interest work? What does savings look like? Even if it's at a very basic level, that stuff needs to be taught at school. That's where financial literacy starts. The value of money.
Absolutely. David, my fund is a standalone fund, right? An employer fund. So I was just thinking the company, as part of its employee wellness program, has financial literacy initiatives that it has in place. And we have financial advisors that are also available to employees. Can our fund, as a standalone fund, bearing in mind the fact that all our members are employees, can the fund not piggyback then on the initiatives of the company?
Absolutely. Oh, absolutely.
All right.
Absolutely. Yeah. No, that would be a very sensible initiative.
Okay. All right. Yeah. Okay. Thank you for that.
Thanks, Cecilia. Thank you. All right. Let's get quickly through this next joint conduct standard on requirements relating to third-party service providers, and then we'll have a 5-minute break. So we all know that financial institutions, including our own funds, rely often on third-party service providers, and those are often providing critical operations, especially for something like an outsourced administrator or even something like a tracing agent. And within the financial services sector, there's been a lot of digitalization. In other words, the moving from paper to screen in terms of how those benefits are brought to us. But if those services provided by, for instance, an outsourced service provider are disrupted, if they are hacked, for instance, if there's a failure, either small or large, within that service provider, that represents a risk to our fund. So what has happened is that a regulatory organ called the Financial Stability Board, they released something called a third-party risk management and oversight toolkit for us as not just for us, but for us as funds to use. And that is going to be pulled into a joint conduct standard. The process is underway at the moment. And it's really just to assess and regulate and monitor the risk of a third-party service provider to the fund failing, tripping, going into liquidation. What are the implications for our members and for the fund as a result of that? Can we have a 4-minute break? I'd love to make it longer, but we've got a lot to get through still, everyone. So can we have a 4-minute break and get together again at 10:40, at 20 to 11, and then we'll move into part 2 of the workshop. Thanks, everyone. And when you do come back, won't you just, like you guys are putting your thumbs up, just give me a sense that you're back, and then we'll move into part 2 of the workshop. Thank you. All right, can I just see who is back? And then we can move into part 2. I'm seeing a couple of hands. Fantastic. Thanks, guys. All right. We are a bit behind in terms of the volume of content that I need to get through. So I will start skipping less important sections in my judgment to get to, excuse me, some of the more interesting stuff. So conduct standard on section 13B pension fund benefit administrators. This is a biggie. What is the background to it? Well, as far as about 4 years ago, a draft conduct standard came out from the Fiscus saying these are what we believe are absolute minimum conditions to be fulfilled and complied with by our third-party benefit administration service providers. And there have been a lot of regulatory and policy developments that have come through in various board notices and so on. And the board notices are very old, that one of 2002. So where we are at the moment is that there's going to be a 6-month transitional period set out by that conduct standard in terms of which contractual arrangements need to be, in terms of existing third-party administrators, need to be upgraded and improved. And of course, we also need to be mindful of, if we're about to engage with a new third-party administrator, we need to make sure that our contract with them complies with the new conduct standard. So the draft conduct standard that's come out, or is in current form, is not likely to be materially different from what is sitting already in the Financial Sector Regulation Act. So this is a good example of alignment between the FSRA and the conduct standard. So it's required quite a lot of toing and froing between the conduct authority and obviously industry bodies, and a number of the industry bodies have commented on the previous draft, and more iterations have come out. But we are, as I understand it, at a point where the sort of the pre-final amended conduct standard is going to be submitted to Parliament for assessment and review. So that all had to be in by the end of September of last year. CISA and the IRFA have submitted their comments as well. And we now understand that the FSCA has presented the sort of the pre-final draft conduct standard in respect of administrators to Parliament on the 1st of April of this year, and we're expecting that then to be finalised certainly by the middle of next year. So the first half of the period, 2025 through to 2026. What are the implications going to be for us as boards of trustees and principal officers? Well, we're going to have to perform a very comprehensive analysis of our administration processes undertaken by a third-party administrator. What do our contracts with them currently say? What are the service levels, agreements which are in existence? Do they comply with the new conduct standard? A lot of focus on fees and fairness of fees in terms of the charges being levied by third-party administrators to the fund and therefore to the members. What are the implications? I think Busisiwe indicated that her fund is self-administered. What are the implications of compliance with the standard? Probably of less interest for self-administered funds, because they're having to comply with all of the member fairness requirements in any case as a self-administered administrator. What are the penalties if there's a breach of the contract? What are the implications? Are there administrative penalties and so on from the conduct authority in the event that a fund continues to engage with a third-party administrator in breach of the conduct standard. All of these are practical implications as this stone is thrown into its particular pond, if you like. All right. The new conduct standard in terms of communication of benefit projections to members. Okay, this has been out under discussion for a long time, and really relates to these models, these especially on fund website or service providers website, where I say I've got R1 million saved already. I'm 35. What are my benefits going to look like if I stay employed, earning this salary, and retire at the age of 60 or 65? It's all of that stuff which is now being pulled together under this particular conduct standard of benefit of benefit projections. So what the draft conduct standard prescribes is the methodology and assumptions used in the calculation of benefit projections. Now, we are now in the world of our actuarial colleagues and advisors. So methodologies and assumptions sit very much within their area of responsibility as stakeholders, especially for the bigger sponsored commercial funds. But of course, from the perspective of the members, as the third bullet point says here, the members are not, and I'd include myself in that as well. I'm certainly not an actuary. We need for the complexity sitting within the benefit projections to be minimized. It needs to be clearly and simply communicated and therefore easily understood by members, and not just members about to retire, but members who are joining a new fund as a youngster. So a youngster of 25, if they've taken their retirement seriously, they're going to want to know in 40 years' time, based on the following assumptions that they're going to put into the model, what their standard of living is going to look like one day when they do retire. So it's quite a complex intersection of very, very sophisticated modeling using all sorts of actuarial algorithms and the like on the one hand, and marrying that to a simple member of your fund and my fund saying, I'm 45 now, this is what I'm earning, this is what I'm contributing, this is what my employer is contributing to the fund. What is my net replacement ratio going to look like one day when I do retire in 20 years' time? So these calculators which are out there are great, but they need to be regulated by this conduct standard in terms of the assumptions and the nature of the benefit projections. And then once it's finalized, the conduct standard will apply to every registered pension fund, other than obvious exceptions like unclaimed benefit funds and beneficiary funds. There is now consideration whether this project, because of its complexity, shouldn't be penned. It shouldn't just be stopped for a moment. And then once the Kofi transition bill project comes into life, that it's included in that. That may be a good sort of resting place for it. Implications for us as trustees and principal officers. It's a very technical part of the industry, as I've indicated already, typically run by highly qualified financial and modeling specialists and actuaries. To what extent are these services going to be provided in an online situation, or do we put them in member benefit statements? A lot of us are now starting to put predicted benefit calculations on member benefit statements, especially where we're identifying a member is falling below the target of net replacement ratios. What are the implications for online versus a paper equivalent of that? Elevating members' financial literacy. This is one of our biggest challenges. And I'm thinking of the comments made earlier by Gugu. We need our members to understand that the more that they save and the more that they preserve during their accumulation years, the better their financial outcome is going to be. So it sits right at the core of that process in terms of a model and a tool to be used in that. What if we get it wrong? Are there liabilities to the fund if we don't comply with the conduct standard? What are the implications of our new best friend two-pot? How do we change the models of benefit projections, knowing now that many members are going to want to withdraw from their savings component, but equally that all members' retirement component cannot be accessed before normal retirement age. These are all, and it's an incredibly important part of the whole process, because there's an element of fear that we need to manage positively in our members' mind by saying, look, member, you are only contributing this, you're earning this at the moment. In 12 years' time, when you retire age 65, you're only going to be getting out 35% of your last salary as your first pension fund, as your first pension, as your first annuity. What are the implications of that? What needs to be changed? All right. An aspect of our fund's workings and administration, which is always quite, which can be quite challenging. Section 14 transfers. A lot of work has been done over the years in terms of understanding where the bottlenecks sit, the documentation issues. So the existing conduct standard, which is now about 6 years old, provides guidelines and procedures. And of course, the forms then became a problem when we introduced two-pot, because what we now need to do in two-pot is we need, when we do transfer from the transfer raw fund to the transferee fund, we now are obliged to analyze which component, which pots are being moved from Fund A as the transfer raw to Fund B as the transferee in respect of each and every member who is involved in that transfer. So the way that Conduct Standard 1 of 2019 worked is that it had attached to it, it had included in it prescribed forms in that old conduct standard, and that became a problem in terms of the flexibility. So what the new methodology is that the forms are going to be removed from the conduct standard so that the FSCA can actually change the content and the form relating to Section 14 transfers without having to change this conduct standard itself. And once that's been done, and to a large extent it has already been given effect to, the FSCA will then amend the forms to accommodate changes resulting from implementation of the two-pot system, and those forms will then be available on the FSCA website. And what it does is obviously creates the flexibility to change the forms without having to change the conduct standard itself. And as usual, an interaction and expression of interest went out, and there was interaction, and then the process has moved forward now to the extent that there's been an acknowledgement that certain exemptions are going to be allowed in terms of form content specifically resulting from two-pot for Section 14 transfers. That's what the communication said. The blue highlights are the relevant parts there. So quite a lot of work then need to be done in the background to make sure that there was alignment of this new change relative to the implementation of two-pot, and certain exemptions were given in terms of facilitating that process. Those exemptions came into effect in September of last year and will continue until the conduct standard has been amended. So for those of you who are not familiar with the new Form A, for instance. Oh, sorry, Sharif, I see your hand up. Come in, please.
Hi, morning, David and everybody. So, David, I was just interested to also understand that, I've been involved in a lot of Section 14 transfers between funds in South Africa.
Yes.
And recently, we now also involved in Section 14 transfer to some members in Lesotho and Swaziland. So, yeah, I'm not quite familiar how difficult that process is going to be. As you understand, it's already a time-use process to transfer members' values from, to the transfer funds. So I was just interested if anybody knows maybe how this will be dealt with from that side, and whether this will delay the process. If we are not familiar, for example, with the regulator in Swaziland or Lesotho.
Yeah, that's an interesting observation. Yeah, because we tend to focus only on our South African realm, don't we? Yeah. Has anyone got an experience to share with Sharif on that one? So where let's say we've got a member transferring to. And it could actually be the same employer group, not so, Sharif?
100%, David. It's yeah. I see Leslie's hand is up. Maybe she can help us.
So Leslie's hand is up. So you've got a situation where you've got a multinational employer who transfers. I'm going to use your name, Sharif, because I know you might be offended. Who transfers Sharif from the multinational South African fund to the Swaziland fund, because that's where Sharif has been transferred to. Leslie, have you got some a solution to help Sharif?
I'm not sure about Swaziland. I haven't had involvement with Swaziland, but the Lesotho one, we actually had employees from Lesotho that were contributing to our South African Provident Fund, and we actually had to transfer them to a fund in Lesotho. I'm sure Sharif knows that. I've had limited experience.
The same experience.
But just for the other people. So on a multinational level, you can't actually have the same. It's got to be a fund in Lesotho. So our consultants had to go and find one that sort of offers on a balanced fund version. And we have submitted. It hasn't yet been approved, but there was, obviously, and also now I think so. It's also been complicated now with this trans-border stuff, limitations on transferring money. Yeah, so it's actually I can't give you the details, but with this, this new SARB stuff, that you can't just transfer money to Lesotho overnight anymore.
Yeah.
And Botswana and company, that sort of came in as well and affected it. So it is ours hasn't yet been finalized, but we did get the right fund for the regulator in Lesotho, and he is happy with the process, but it is still it's a month or 3 now in the process.
Interesting. And of course, you've got a cross-currency issue there as well.
Yeah.
Because your transfer all funds, assuming that the transfer is going to Swaziland, Lesotho, whatever, is in rand. So you've got a cross-currency implication as well. That's fascinating. Thanks, Leslie. Thanks, Sharif, for the question.
Thank you, guys.
All right. So for anyone who's not involved in signing Section Form A's, or Forms A, I suppose I should call them, this is what the new look for the time being is like. There's a new section, a new inclusion at item 4.2, where when we transferring David across from, and David, I'm just using myself as an example of a cohort of members moving across from a transfer all fund to the transferee fund. The transfer all fund has to now split up the members' share of fund. Before it was just a rand value share of fund. Now, of course, assuming that the effective date is after the 1st of September 2024, which is the implementation date of Two-Pot, David's share of fund now has to be split between his vested component, and of course sitting with invested component is the vested benefit and the non-vested benefit, probably if it's a provident fund, savings component, retirement component. And I cannot stress enough how important it is to get this right as the transfer raw fund, because if the transfer raw fund gets it wrong and the split this analysis across the 3 components wrong, the transfer refund is simply going to take it as gospel truth that David has got 100,000 invested, 10,000 in savings, and 1 million in retirement. But if the transfer raw fund has got the split wrong, that error, that deficiency in my 3 components that I as a member now take across with my fellow members who've gone across with it, that is going to live with me and with my fellow members, unless it's corrected, for the rest of my time in the retirement savings industry. So it really is so important that we comply with this, with the accuracy and provide the so-called Appendix 6 schedule that accompanies this analysis of the 3 components. Are there any POs here who want to comment on the challenges that they've encountered using the new Form A? Marilyn.
Hi. Yes, I do lots of Section 14s, and the forms are fairly easy. You've just got to make sure that your schedule that accompanies them is as per
Appendix 6.
Yeah, it's 6. So we've developed one that includes the figures, but it's quite complicated because you've also got to put in there whether or not somebody has taken out money from their savings pot or
savings
not.
Withdrawal, yeah, absolutely.
So sometimes, depending on the Section 14, you might need to put the normal information in, and then what we do is we say additional information is contained in the schedule that accompanies the Section 14, and then we don't seem to have a problem.
Okay. And then we hope with our fingers crossed that the transfer refund loads it correctly in terms of that group of members, don't we?
Yes. So, well, and then also you found that some people are now submitting without a further breakdown of the employer and member contributions, because they're seeing it being accepted at the top, and then it's broken down into the savings pot and the retirement pot. And so when they do that schedule, they leave off the member and employer contribution. And some funds, like one of the bargaining councils, they have to have that information. It seems like others don't seem to be asking for it anymore.
Sure.
But I think it is important. And I think we've adjusted our schedule to take that into account now as well.
Fantastic. So that's very responsible of you.
Yeah, other than that, it actually works well.
Okay. Oh, fantastic. Thanks for that input, Marilyn. All right, let's now get into another area which is going to become a point of some change for us in our trustee and PO lives. Regulatory reporting and annual financial statements. Now, you know, the existing annual financial statements format for retirement funds goes back to the 1980s, as I understand it. So, you know, the world has changed so much and so dramatically in the intervening period. So, now, notice that this standard, because it falls within the prudential area of governance, we've been used to engaging with the FSCA on our annual financial statements. This is an example of a governance and administrative function, which is in fact going to move to the prudential authority. Okay, and that's why it's a so-called prudential standard. So it's quite complicated in that the auditing profession has also had to become attuned to this and involved as a stakeholder in the process to upgrade and improve and get fit for purpose our various regulatory reporting, but especially annual financial statements. So our current situation is governed by a number of different board notices issued under the Act, under the Pension Funds Act, but they are to some extent outdated. I think that's a bit of an understatement. So the Prudential Authority has come out with the standards saying there needs to be alignment, not just in terms of the format of annual financial statements, but especially alignment with the recent amendments to Regulation 28, by which I mean we are now permitted to, as funds, to invest into hedge funds or into private equity or infrastructural investments. So there've been a lot of changes where the reporting formats and annual financial statements have simply not kept up with it. So this has resulted in this misalignment between the regulations and where we are now. So these are created challenges for not only the funds but also the auditors. So as a result, the Regulation 28 audit and Schedule IB1 especially has required the provision of an exception in terms of certain elements of that reporting. So the Conduct Authority has historically engaged with the auditors, their regulatory board, the Independent Regulatory Board for Auditors, and the IRBA has come back and said they're not opposed to that exception as an interim measure until everyone can catch up and be brought to be brought into alignment. So a number of exemption notices have been issued in terms of the FSCA Notice 26, and exemptions have been given to large funds in terms of completion of Schedule D, the audit report, and exempt funds, especially for assets held in compliance with Regulation 28. So it's quite a technical area of the reporting sitting within our annual financial statements. But the alignment will eventually come through, and ultimately there'll be a new prudential standard which will replace the very elderly board notice 77. That work has been continuing now, as I said earlier, within the Prudential Authority, and there's an anticipation that standard will be complete by the end of this year. And if not by the end of this year, very early in 2026. So for those of us who are involved in the preparation of annual financial statements, and especially the Reg 28 schedules to those financial statements, that's going to be quite a significant change that needs to be brought into our lives. It's going to require additional collaboration with our statutory auditors, our external auditors. That will have a fee implication, which needs to be factored into our governance expenses and budgets. Our board are going to have to understand, especially those of us who are not particularly au fait with or understand Reg 28 in its detailed complexity. So there may be a bit of board training required. And what it'll also do is it'll add additional pressure to meet that year-end plus 6 months deadline currently required by the Act in terms of getting fund annual financial statements out. Has anyone got any sort of practical experience or stories to tell in terms of their compliance with this new arrangement? I'm looking for POs especially. No, I don't see anyone on that one. All right. That then leads us into our what is now called a holistic Reg 28 reporting initiative, which has been started. And that has its origins in the identification of a need to add an additional layer of quarterly reporting for funds in compliance to maintain better compliance with Regulation 28. So at the moment, there's a fairly light touch in terms of reporting to the SARB, especially in terms of Reg 28 detail. What's now going to happen is that there's going to be an enhanced quarterly reporting of Regulation 28 details, which will then be monitored and reported back. So this will sit on top of the existing quarterly reporting, which is currently being done, and all the POs present will know what that is, and will hopefully enhance on a holistic basis the reporting on the fund's investments held in compliance with Regulation 28, and an advantage stemming from this is that there won't be a huge process of additional disclosure and reconciliation preparation for the year-end annual financial statements. Because we're doing it on a quarterly basis, it should ease some of the pressure in terms of the year-end annual financial statements, Schedule IBs. So the thing has gone out as a draft prudential standard for public comment. That's been out for a while already. And with the feedback from the industry was this thing needs to be done on a phased approach. We can't do it in a one size fits all overnight big bang process. It needs to be done on a phased approach. So a revised version of the conduct standard came out and indicated that the focus initially certainly would be on exception reporting, and that a new process of consultation would be started in terms of this holistic reporting in terms of Regulation 28, specifically because it is so complex and the numbers need to be sourced from asset managers, and it's quite a process to pull the whole thing together. So the thing is underway. The prudential standard is going to be called Regulation 28, Quarterly Reporting Requirements for Pension Funds, and those of us who are involved in the preparation of annual financial statements and Schedule IB going to have a very real impact on that. But even if we're not involved, as trustees, we need to have a working understanding of the change because we are signing off those financial statements to include that. So the Prudential Authority has earmarked the end of this year or very early next year for the completion of that. And once it is promulgated and becomes of effect, it will replace the current Prudential standard, which is currently in use. So implications for us as trustees. Initially, I think maybe slightly cynically, there will be an increase in complications, certainly of understanding, setting up systems so that we are reporting on a compliant basis. But like all things in our industry, once we're over the hump of it and we've got our stuff sorted, it will become part of our normal working lives, I guess. Let's switch quickly to a discussion on the conduct standard in respect of living annuities in an annuity structure. So you'll remember that Regulation 39, when it came out, created a default requirement, an opt-in requirement of the fund to establish, if it wished, in terms of its rules, to establish an annuity strategy. In other words, to pay pensioners out of the fund itself, rather than having the members purchase the annuities from outside providers. So what happened as part of that process was that the criteria for these living annuities, obviously a guaranteed or life annuity is an insurance product and needs to be acquired from a life insurer, but a living annuity may, if the fund rules permit it, be provided as an investment product to members by the fund as they retire out of the fund. So a number of processes we've gone through. The conduct standard in its draft form went out for public comment, and those comments were submitted back. So the nature of the feedback has been such that the FSCA is not yet in a position to publish or release a final conduct standard. I think predominantly because of the assumptions which are sitting within the requirements of a living annuity. So at this point in time, we're not quite sure when the FSCA is going to come out. In fact, continue with the work on the draft conduct standard on living annuities, or what form it's going to take. It seems to have been sidelined to an extent. I'm sure there are good reasons for that, but it's something that we do need to bear in mind when it does come out. So for the time being, our annuitants in our funds where we do issue a living annuity, or it allows a living annuity to be provided by the fund, we are still sitting in our quite long-standing percentage table range of 2.5% to 17.5% per annum as a drawdown. That status quo remains. But again, it's important to always bear the members in mind in these situations. Members still need to be told that even though this is the current status quo, it may well change once this new standard becomes finalized and issued. A brief comment on guidance notes and interpretation rulings. I think historically the approach has been that a guidance note would be issued or an interpretation ruling would be issued by the regulator when they needed it, but either as a result of an industry request or where there was some sort of ambiguity that needs to be clarified. But what has happened is that these things have come out on an ad hoc basis from the regulator. But they do represent a very important. They do play a very important role in the regulatory framework. But the move, as we talked about earlier, is to move from to a more outcomes and principle based process, and therefore there needs to be a new way for the FSCA to approach how they deal with guidance notices and interpretation rulings. So there have been lots of discussions within the FSCA. They're still formulating how they're going to approach guidance notices in the future, and especially the fact that the current regulation plan does not set out a lot of detail in terms of how they should do that. But in simple terms, the third bullet point here is the one that we should take away, and that is that regulation plans will have a more structured approach in terms of how guidance notices are used, the practical implications of them, a more streamlined methodology, if you like, in terms of guidance notices, which play such an important part in our lives. I'm not going to spend too much time on securities lendings. What we really mean here in layman's terms is where we are, as a fund, we're invested into assets which are then used for so-called scrip lending. That's what we mean by securities lending. So this goes back some way in terms of attempted regulation. It goes back 5 or 6 years already. It's trying to establish high-level principles in terms of how scrip lending is to work for assets owned by members ultimately through their fund. The process is still really on hold because it overlaps with a number of other developments relating to securities lending transactions with not just funds but also banks and insurers. But the FSCA has assured us that work will be resuscitated on this when it does happen. All right, I'm going to accelerate through this section here on Directive 8. Bear in mind that everyone is getting a copy of these slides as delegates to the workshop, so don't panic if you feel that you've missed something. All right, let's have an update on our old new friend, the two-pot system. Just for those of us who need reminding, and there can't be many, it's the single largest change to the retirement savings industry, for a third of a century, and all sorts of challenges were encountered in terms of rule amendments and systems changes. We all remember that with not necessarily the best memories, but we're there. So some feedback from the pension lawyers. In terms of their some slides that they put together in November of last year. Let's dip into a couple of those. They provided a bit of feedback. Sorry, they asked feedback from 4 different administrators on behalf of the 4 different funds. They asked some questions. For instance, are your savings withdrawal benefit claims starting to level out? What sort of trends are emerging in terms of savings withdrawal benefits? What has happened, for instance, on the SARS front, especially the dreaded IT88s? Are members still kicking back against having outstanding taxes withheld before the savings benefit withdrawal is paid out to them? What sort of age bands of members took savings withdrawal benefits. Quite interesting responses that we're going to see in a moment to these questions. What kind of communication methods were used to enlighten members? So for anonymous, these were big funds. 4 anonymous fund administrators gave feedback in terms of their particular funds circumstances. So a couple of the blue highlighted stats are quite interesting and worth sharing, I think. So the first one is, what percentage of two-pot savings withdrawal benefits?
Whatever you're attending is not.
Sorry, I can see on a microphone that's gone. Okay. What percentage of two-pot savings withdrawal benefits were claimed as a percentage of the total membership? So in Fund A, 22% of members, not rand value, of actual members, drew down on their savings component, their savings pot during 2024. Compare that with Fund B, where only 7% of members withdrew. So one can speculate as to the reason for that. I would guess that Fund A's membership profile is probably, without attempting to be offensive or patronizing at all for a moment, are probably lower paid members, lower paid workers, lower paid employees, compared with the membership profile of Fund B. But look at the difference, a threefold factor. The next interesting feature was, what percentage of savings withdrawal benefits had IT88 implications? And probably for the same reason, 1 in 9, 11% of Fund A's application for saving withdrawal benefits triggered an IT88 response from SARS when the tax directive was requested. So again, not necessarily correlated, but very different from Fund B, where it was only 5.5%. As a follow-on question to that one, how, of those instances where there were IT88s triggered by a request for a tax directive for a savings withdrawal benefit, in how many of those cases did those IT88s clean out the savings withdrawal benefit requested? And in Fund A, it was 1 in 5, 19%. 19% of those members who submitted claims for savings withdrawal benefits, all of that money, all of those savings withdrawal benefits went to settle existing debt to SARS. It's a very interesting, I think it's a very interesting set of statistics. While we're still on two-pot, let's have a look at these. What is the average pensionable earnings? And this is really cause for grave concern from a high-level socio-economic perspective in South Africa. So the average earnings, pensionable earnings in Fund A, 153,000 Rand a year, closer to 200,000 Rand for Fund B, 260,000 for Fund C, and about 250,000 Rand for Fund D. What it demonstrates, certainly in my experience, is one of the causes of the low levels of contribution rate in South Africa is the low level of average remuneration, and that's a broad generalization, obviously, that I'm making. So within those funds, people earning between up to 237,000 Rand, and these are obviously the tax bands which they're using. The vast majority within Fund A of the members drawing down on their savings pot, the vast majority, 85% of them, were earning 237,000 Rand and less. So again, one's tendency is to believe that Fund A had a large so-called blue collar, or maybe LSM 4 through to 7 profile of that membership base. Compared in this case, for instance, with Fund C, where only 1/3 of the members who access their savings component were earning up to 237,000 Rand per annum. It makes for some quite interesting statistics. But I'm not going to go through any more of these. They'll be in the pack. And just acknowledgement to the Pension Lawyers Association for the source of that. What the FSCA has done, though, since the implementation of Two-Pot, they have expressed concerns regarding the differences in fees being charged by members making a savings benefit withdrawal. And they came out with a request for information in September of last year, and we all had to submit our stats back in terms of assessing so that they could assess the impact of those fees. And first and foremost, the FSCA was, as usual, concerned that the implementation of Two-Pot and the fees that were now being triggered, whether those were in fact treating members fairly. Were the boards of trustees who'd approved those fees in fact acting in the best interests of the fund and its members? Because the normal test would be, are those fees reasonable in terms of the processes, the change to the system, etc., resulting from the implementation of Two-Pot. So what the FSCA requested those administrators for was the following detail: estimated costs incurred in administering the Two-Pot system, including adapting the system, staff training, member communication, everything that we all went through from January to August of last year. Estimated setup costs, fidelity cover, what sort of other costs were incurred in terms of the implementation of the Two-Pot system, especially increases in administration fees, and how they were going to be apportioned across members and how they were going to be recovered from members. And then the funds had until the end of September to respond on that. And then also a request in terms of administrators' capabilities implemented to submit savings withdrawal benefit requests. In other words, was it paper-based? Was it digital? Was it WhatsApp, social media? All of that information was requested. And the feedback has been quite interesting for those of you who haven't seen it. The FSCA then analysed and collated all of the responses and came up with a response in March of this year, and found the following: the largest part of the cost included in the fees or factored into the fees resulted from adapting systems to enable the administration of the Two-Pot system. The next largest cost related to staff and staff training. All right. Look at the spread of fees that the survey showed. 28 administrators. Now these are big administrators by and large. Some of them were smaller, but obviously the questions were pitched at bigger administrators so that the FSCA could get a bigger picture of the whole ecosystem. 28 administrators indicated that they charge no transaction fee for savings benefits withdrawal. Now, I'll come back to that in a moment. 37 administrators charged a flat fee ranging from 50 Rand to 500 Rand per withdrawal. And then 12 administrators responded that they charged a variable transaction fee. Now, the FSCA adopted a very interesting stance on the first one, the administrators that didn't charge any transaction fee. Their concern was, if you're not charging a transaction fee, how are you going to be recouping the costs that have been incurred in setting up your administration systems to enable savings withdrawal benefits payments to be made? And if they haven't incurred those costs, are the administrators in fact complying with their responsibilities? Have they in fact not built additional systems to give effect to reliable and accurate savings withdrawal benefit amounts? So that was their one concern. are other concerns with that there's going to be a long-term effect of fees into the future, and that's going to be difficult to determine and ascertain in the greater scheme of things. It's all very new. Different administrators, different sponsors, different funds are going to adapt to the situation differently in determining how these fees are going to be recovered. They've put out those responses in their quarterly newsletter, and I would urge everyone to go into the FSCA newsletters when they do come out, because it's not just on Two-Pot, but they do report back to the industry on a wide range of matters and concerns and updates that do come through. A more recent development on Two-Pot is the matter of retrenchment. And here I'm looking for Busisiwe, come in, please. It gives me a chance to have a sip of water.
Thank you very much, David. Colleagues, I was just thinking, I find it, yes, some administrators are not charging any fees, but I find it incredibly unfair for the government to expect the employees to fund the implementation of the legislation, which is inevitable, which I believe the effect of these fees are. The individuals are the ones who are funding implementation of a legislative change that was made by the government.
Yeah.
In my view, I think, which is incredibly unfair, because, you know, the employee who is hard done by and financially stretched to the maximum is already at a disadvantage minus Two-Pot. Then they have access to the Two-Pot money. Then there's the administration fee, which the member doesn't really have any ability to negotiate on. Yes, there's a board of trustees, but as an individual member who's withdrawing that money that belongs to them, the fee is set somewhere else, you know, and then money is paid over to SARS. In my view, a portion of the money sent to SARS should have been dedicated to implementation of the statute, and they could have had a fixed fee. It could have been a legislated fixed fee. For example, if 50 Rand for every member, 150, whatever per member, and that is deducted, you know, from the portion that will be paid to the receiver of revenue. I find it incredibly unfair for the members who already, because I think, David, I don't believe the majority of the members, in my view, this is a personal view, right? And I stand to be corrected, and colleagues, feel free to correct me. I'm of the view that those who did go and withdraw the money from the Two-Pot are individuals who are really, really in dire, you know, conditions, people that actually desperately needed the money. And, you know, I know some of them use the money to pay off loan sharks. Some of them use the money to pay, you know, school fees. I don't think anybody was taking the money and then going to Monte Casino, you know. So for me, it's like already the person is disadvantaged.
Yeah.
They've reached their maximum in terms of the avenues available for financial relief for themselves and their families, and then you then charge them that, you know, that fee. It might be a very low amount, but for a person who's in a corner financially, every cent actually counts. Yes, every cent actually counts. I find it incredibly unfair. And for me, I think that it's something that I think we could find a way of mobilizing and engaging with government, right? To say, you know, fine, they implemented this, but as an industry to say we are not happy with this, and, you know, it could be done other ways. We should not prejudice the members who are already being prejudiced, because at the end of the day, after the members have reached their retirement age and they've withdrawn their Two-Pot and they've paid the administration fees and they have paid SARS, they still won't qualify. Yes, they will still won't qualify for any support from the government.
Yeah. No, great insights there, Busi. And I'm going to add another one to your list. You and I, Busi, you and I are the two members in our fund, hypothetical fund. They're just two members in the fund. We both have we both have 100,000 invested, and it doesn't really matter where it's in savings component or retirement component. Because of Two-Pot, our administrator has now had to build new systems. Excuse me, they've had to do staff training, they've had to do all sorts of additional things. I now make my, and that's cost R500,000, for instance, to the administrator. I now make my withdrawal, and I'm charged a fee. Okay.
Yes.
But you haven't claimed you haven't made a savings benefit withdrawal out of your savings component, because you have no need to. You're a lady. You manage your affairs, your financial affairs better. So, but that 500,000 rand, which is being paid by the administrator, is going to be recovered as a governance fee. But it's not just going to be recovered from me. It's going to be recovered from you as well. So, yes, now we've got this inequality within the body of members, in that the members who are not making savings withdrawal benefits are cross-subsidizing the members who are. Do you understand what I'm saying?
Absolutely. Yeah. I absolutely do understand.
So there's going to be a lot of kind of ironing out of the post two-pot implementation system, and that takes me on to the next slide. Thanks for that, Busi. That's great feedback. What now about somebody who retires? Sorry, a member who is retrenched. What about a member who is retrenched? Because in the old situation, what the tax table said was, if a member dies or is retrenched or reaches normal retirement age, they will benefit. They will receive certain specific benefits, 550,000 rand tax-free at that point. Now, though, post two-pot, we have a retirement component which cannot be touched until normal retirement age. But David has now been retrenched. Now, in the previous regime, I would have been able to access all of my retirement savings, and that was especially sensitive because I'd been retrenched and I'd lost my job and I needed to feed the children and educate the family, etc., etc., etc. Now, however, that member's retirement component is locked in there. And the only basis upon which David's going to be able to access his retirement component is waiting until normal retirement age, or if he dies in service, it's going to be paid out as part of the Section 37C benefit. So there's been pushback to the government to say, look, we need to modify the two-pot system so that in the event of retrenchment, there has to be some leniency given to the circumstance of the member. Now that flies directly in the face of the whole purpose of two-pot, of locking away the retirement component. So it's going to form part of the so-called second phase of the two-pot reformation process. And there was mention made of it. I didn't hear it myself, but mention made of it in the budget speech that work has already been started in terms of allowing access to the retirement component in the event of a member's retrenchment and they are financially distressed. How that's all going to be measured, remains to be seen. But it will be only in situations of very strict conditions that access will be allowed. So two-pot in general, implications for us all going forward, deep and comprehensive issues that still need to be ironed out, especially members' misunderstandings. There's still a lot of member upset and unhappiness, especially now that we're into the next tax year, the tax year ending February 2026. There's still resentment about the tax being withheld. Busi's explained concerns about unfairness relative to fees. How are we disclosing you know, the three pots in terms of member benefit statements, booklets, member communication, and of course we also have 31 December annual financial statement preparations coming up. For those of us who are at 31 December 2024, big changes before the end of last month for the submission by the 30th of December 2025. But we've got to start thinking about those of us with December year ends, what processes and changes and adaptations are required now in terms of compliance with, not just compliance with two-pot, but all the other ramifications and ripple effects that two-pot have brought about for our 31 December 2025 annual financial statements. So quite a lot still. Two-pot is not a driving license where you pass it and you can then drive until you're 65. You know, it's a live situation with member circumstances changing on a kind of a daily basis. All right, let's go into some of the closing parts of the workshop. Let's have a quick look at the trustee toolkit, but a specific aspect of the trustee toolkit, people, because it's non-compliance that we're going to look at. Of course, we all know the trustee toolkit was upgraded from 11 to 22 modules back in 2023, and existing board members had until the 30th of September to complete all 2022 modules. Let's have a look at how that compliance looked. So back in October of last year, at the IRFA conference, the FSCA came out and said they had about 80% compliance with phase 1, in other words, the first 11 modules, and about 84% compliance with phase 2, modules 12 through to 2022. They had, from the beginning, warned us as an industry that non-compliance by trustees with the trustee toolkit would result in regulatory action. But in October, it didn't look too problematic. What has now subsequently happened, that the FSCA went out and made an information request, and they asked for a whole lot of information, specifically in terms of trustees who had completed it and those who had not. And again, following up on their warning that they were going to take appropriate regulatory action against non-compliant trustees, and that detail was all submitted towards the beginning of November of last year. Look at what's happened. They've now produced updated stats as of last month, 25th of June of last month. Look at what the completion rates look like now. 5,200 trustees have completed. 6,400 trustees have registered, but have not all completed the 22 modules, and about 1,200 trustees remain non-compliant as of last month. Okay, what is the FSCA doing about this? Well, they've issued so-called Section 26(4) letters, 1,000 of those, 962 of those, giving those non-compliant trustees 30 days to motivate why they should not be removed as trustees. So for the first time in a long time, the FSCA is actually coming good on enforcement. I think it represents a good trend, and I think it demonstrates their intention to carry out the regulatory actions which they've warned us, which they've threatened us with. And I think that's good, because why should all of us work through the weekend, you know, getting our trustee toolkit done, and then we hear of other trustees in the industry who don't bother because they're never going to get caught? There's a great sense of inequality and unfairness in that result. So for one, I'm impressed and I'm relieved with the regulatory action which the FSCA has applied in terms of following up on non-compliant trustees. And of course, as the second bullet point indicates here, the next step in the process is going to be a naming and a shaming. All right. There have been the opportunity for exemption applications to be made by the FSCA, especially from terminating funds. But what the FISC have come back again, to their credit, they've come back very firmly and said it doesn't matter where the trustee appointment is, whether it's a terminating fund, a live contributing fund. There is the expectation of compliance with the trustee toolkit, with the trustee toolkit requirements. And of course, failure by any board not to provide that information represents an offence under the FSRA. Leslie, I'm fascinated to hear your contribution.
We had 2 trustees that by March had not yet complied. And we kept reminding them, putting it in the board pack, everything. And then round about May, myself, PO, and the chairman and the vice chair actually sent a letter to the 2 trustees and said they would be called to defend themselves in the June BOT as to why they should not be removed, because actually both were being re-elected or standing for re-election.
Good for you.
And the one trustee particular has a lot to offer the fund. He's the BOT. He's incredibly diligent. He's been on for 20 years. He has a lot of knowledge, etc., etc. And we didn't want to lose him, but yeah.
So he was diligent except for doing his trustee toolkit.
Yes, and they actually came to the party and did it within 2 weeks.
There you are.
Yeah.
Well done. But what a great, I mean, that is such a great story, Leslie, because instead of waiting for the FSCA to beat them, you took it upon yourselves internally to enforce compliance. I mean, that's just excellent governance in action, isn't it? Well, absolutely well done. All right. I'm just going to. In fact, we've run out of time because I don't want to go beyond 12, and I do want you to complete your post workshop questionnaire. So the rest of it is all sitting in the pack. So if you'll please just look to the chat box. And Sabisa is going to be posting a couple of links in the chat box. Are you there, Sabisa?
Yes, David.
Have you? I don't always see the links when they posted. Have you posted the post?
The links.
Workshop
Yes, I
ME
did.
link?
Yes, I did.
Oh, you have. Okay.
Yes.
So everyone, I can't see it on my chat box, probably because I'm presenting. But if you go to your chat box, everyone, please. It's mandatory that you click on that first link, which is the post M&E questions. And what that'll do is when you click on it, it'll take you through to exactly the same questions that we asked you when you registered for today's workshop. If you can click on that link, same questions, 3 knowledge questions, 3 confidence questions. The reason why we ask you the questions is that we have a funding mechanism through the Assisa Foundation. And they in turn have an audit process which needs to demonstrate that that's the reason why we took the photograph at the beginning of the workshop, amongst other things. We need to be able to show and monitor and assess whether there's been a transfer of knowledge and an improvement in the confidence levels of the content of the workshop. So please, it's mandatory that you click on that, complete the questions, submit them to Sabisa, and then she will include that in her administrative process. And then secondly, you'll see another link which is not mandatory, it's voluntary. If you click on that, it'll give you the opportunity to assess today's workshop, whether there was too much content, and I did warn everyone, for instance, that was going to be the case. Me as a presenter, suggestions in terms of improving the program, that's a voluntary link. But please, it's absolutely mandatory to in order for us to offer these workshops to you free of charge, for you to complete those questions. I'll be around until after 12 to field any other questions in relation to what we talked about already. if anyone is unable to see the link in the chat, then please do let Sabisa know now on the workshop still, and Sabisa will email you the questions so that you can then complete the questions and then return them to her, please. I'd also like to acknowledge the significant support and input by and from Lisa de la Harpe. She's been an amazing resource in terms of providing us with much of the content that we've talked about this morning. Thank you. Thanks, Lisa.